Courts and crimes. So if you report crimes and court proceedings incorrectly, you can go to jail, which obviously you don't want to do. You will not go past go. You will not collect £200. So just to give you, if you're a bit unaware about how courts and the criminal justice system works, this is going to be a whistle-stop tour of just a kind of a basic overview about which courts do what and what crimes are which. So we'll start with what's the difference between civil and criminal cases. So civil, or civil courts, civil offences, are for suing. So that would appear on docket as blogs v doe. So that's people against people, people against corporations, corporations against people, or corporations against other corporations. So it's also used, in addition to suing people, is possession orders, evictions, claims, bankruptcy, small claims court, things like that. And it's all between people or companies. Crimes are against the person, but prosecuted by the Crown, and the people who prosecute the crimes are called the Crown Prosecution Service, or the CPS. This would be written down, it is Crown v Blogs, but it would be written down as R v Blogs, and as a short tidbit, the R stands for Rex, being a king, or Regina, if there's a queen. So you'll just see it down as R v whoever, and the R being the crown or the king or queen of the day. So types of criminal offences. There are 3 types: summary offences, and summary offences cover the most minor offences, such as common assaults, drunkenness, speeding offences, and they're dealt with at magistrates or mags, as some people will say. They're the lowest end of the criminal justice system, and they'll most likely be tried at magistrates unless they're facing murder charges, at which point they'll all be lumped up straight up to the Crown Court. Either way offences are for distressing crimes between minor and major crimes. So this would include theft, sexual assault, assault causing grievous bodily harm. They'll be heard at magistrates' courts, but if it's too serious, it will go up to the Crown Court. But if it's fairly minor, they'll be sentenced or will be heard at magistrates. Indictable-only offences are for the most heinous crimes, and that would be rape, that would be murder, that would be robbery, and everyone will appear at the magistrates' court, no matter what you're charged with, but the magistrates' court will automatically decide that it is too serious for them to deal with, and it will go straight to the Crown Court after that. So what makes a criminal offence? What is a criminal offence? Essentially, you have to have 2 parts. The actus reus, which is carrying out an act which is potentially criminal, or the Latin is the guilty act, and mens rea, which is the guilty mind, or the kind of premeditation, or so you've got the act and you've got the mentality. For some offences, you don't have to have the mens rea. For all other offences, you have to have both. For some offences, you don't, under the strict liability, which is where you commit a crime and you don't mean to. So, for example, speeding or drink driving, you might not intend to speed, you might just go over the limit. So even though you don't have that mens rea, you have committed the crime, so it's still a criminal offence, even if you didn't mean to do it. So the definitions of crimes are: murder is an indictable-only offence, and that is the unlawful killing with the intention to kill, or the intention to cause grievous bodily harm. So murder being someone actively wanted to kill or to seriously injure someone. Manslaughter, which is also an indictable-only offence, is unlawful killing without the intent to kill or to cause serious injury. Corporate manslaughter is if a senior management team cause a death in a gross breach of duty of care. So, for instance, if a university knew about a problem and then it turned out that problem then later killed someone would probably be charged with corporate manslaughter. Causing or allowing the death of a child or a vulnerable adult is also an indictable-only offence. And this plugs the gap where abusive parents could say, well, actually, I didn't kill them, my partner killed them, and if they both say that, well, that's reasonable doubt right there. So both parents would be charged with causing or allowing the death of a child or a vulnerable adult. Infanticide is an incredibly narrow definition, and it's the killing of a baby less than 12 months from a mother that is suffering distress as a result of their birth. So that would in most cases would be postpartum depression. Assault or common assault is a summary offence, and it's a hostile act or putting someone in fear of immediate violence. Now, this doesn't actually mean that there was any violence. Just putting someone in fear of immediate violence is assault. So raising your hand to someone would be an assault, even if you don't actually strike them, which comes on to battery, or an assault by beating. And for this crime, it should be proved that it's reckless and intentional, and obviously by beating, that is the physical act of assault by beating. So long as it's not religiously or racially motivated, because obviously that's a hate crime, and it would go that way. Assault occasioning actual bodily harm, or ABH, is an either way offence. So the threat or the attack is more than transient and trifling. So that might be like a broken nose, where it's not permanent disability, but it wasn't just a quick slap. Wounding or inflicting grievous bodily harm, GBH, is an either way offence. Both of these crimes must be malicious, and usually where the defendant intended or foresaw causing harm to the victim. Wounding in this particular instance is a piercing of the skin, so whether that's by a knife, needle, anything that pierces the skin is wounding. GBH tends to be more more serious, so broken bones, significant loss of blood, disabilities, something more permanent. Wounding with intent, or GBH with intent, is an indictable only offence, and it's very similar, but they intended to cause the grievous bodily harm. It's also, if it wasn't with the intent, but also with the if they resist lawful apprehension for that crime, and the maximum for that is life in prison. Theft is an either way offence, and it is the dishonest appropriation of property. Now, this is, say, where someone pickpockets. It is stealing. It is a non-violent offence. Robbery is a violent offence. I'll come on to making sure that the two crimes, you make a distinction between the two. Robbery is an indictable only offence, and therefore much more serious, and it is theft, which is the dishonest appropriation of property, by force or threat of force. Think of theft as pickpocketing and robbery as muggings. So theft being the non-violent crime, and robbery being a more violent or threat of violence used in that crime. So handling, this would be handling of stolen property, is an either way offence, and is dishonestly receiving, retaining, removing, disposing or selling goods or knowing or believing them to be stolen. It's fairly self-explanatory. Burglary is an either way or sometimes indictable offence. It's trespassing, which is a civil offence, and then attempting or actually stealing from it. Or the attempt to inflict grievous bodily harm to anyone inside the property, or trespassing with the intent to steal, inflict grievous bodily harm, or do unlawful criminal damage. Aggravated burglary is very similar, but with a weapon or an imitation weapon. So even if it's a plastic gun, still counts as a threat of force, and would still count as a weapon in that instance. Fraud is very complicated and is either way or indictable depending on the case. It is dishonest false representation, or the dishonest failure to disclose information when required, or the dishonest abuse of power. Now, fraud is very complicated, and do always take advice before writing something about fraud. Do always double check, because it's very, very complicated. Blackmail is an indictable offence, and is shortened down as a demand with menace for gain. For example, if you said to your housemate who's been in a long-term relationship, "Oh, I've got photos of you cheating on your girlfriend, and if you give me some money, I will stay silent," you are demanding something with menace. The menace being, well, I'll ruin your relationship, for gain, either being for money. It doesn't have to be for money. It can be for any favour, silence, for anything that you would gain from. Taking a vehicle without authority, or without consent is when it's shortened to TWOC, is a summary offence, and it's not theft, as it's not the intention to permanently deprive the owner of the vehicle. It's mainly used for joyriding. Aggravated vehicle taking is an either way offence, and is where someone is injured or the property is damaged whilst a TWOC crime is in commission. Driving under the influence of drink or drugs is a summary offence, as is driving with excess alcohol. And coming on to the more serious driving offences would be causing the death by dangerous driving when under the influence of drink or drugs, which is an indictable only offence. Perjury is indictable, and this is where you knowingly give false information under oath. Perverting the course of justice is also an indictable offence, and is where you, a defendant conceals or gives false information when required. Wasting police time is a summary offence, as is curb crawling or soliciting.